Good evening, everyone, and a very warm welcome. Thank you for taking the time to join us today and being a part of our webinar series. So, for this session, we will be covering wills and estate planning, which is a crucial step and can have a huge financial impact and make the lives of your heirs much easier in a country that's still bureaucratic when dealing with a foreign jurisdiction. So before we begin, just a disclaimer, this webinar will be recorded and published on our YouTube channel. So we will drop the link in the chat and be sure to subscribe. We'll also share contact details in the chat, and you know the drill. The first 30 people that contact us with the code SGP or partner to moving to Portugal will receive a free initial consultation with our team. So for those of you who are new here, I'm Marisa Colasso, and I'm part of the team at SGP Sandra Gomes Pinto Associates. And I'm joined today by Dr. Sandra herself, who is a practicing lawyer with over 30 years of experience supporting international clients with relocation, investments in Portugal, litigation, and a wide range of legal matters. She has also spoken globally on Portuguese visas, investment opportunities in Portugal, litigation and arbitration, and has also lectured in one of the top universities in the world in Heidelberg. So, Dr. Sandra, for those who don't know you yet, could you briefly introduce yourself, your firm, and the full range of services that you provide?
So, my name is Sandra Gomes Pinto. First of all, thank you so much, Marisa, for doing this with us. And thank you for all the audience that has been attentively and continuously attending our webinars. I'm a lawyer here in Portugal for over 30 years. I always worked with international clients, both firms investing here and also private persons. I've worked, as I said, over 30 years. I was a partner of a big firm in Portugal for 17 years. Last 10 years, I created my own firm. I have assisted in important projects in Portugal, such as the enlargement of the bridge in Signabil as a lawyer. Also, as a lawyer, I was partially responsible for the renovation of a German school, which was a project and something the German government wanted. So, and I also took part of important litigation processes. I speak all over the world about investment in Portugal, visas, tax benefits, litigation, arbitration. These last 10 years, we have other teams of litigation, but we focus a lot on people and individuals and companies relocating to Portugal, moving to Portugal, and all the legal process. So our focus is legal, but we also have a relocation team that takes part of the other thing. So we make sure to have our focus is to be of service, to have a positive impact on the relocation, be very up to date to every detail of each consulate, each AIMA, each novelty, in order that we can guide with a certain security our clients through a process and through a country that still has subjective powers and unstandardized bureaucracy.
Yes. And to talk about wills and estate planning, a lot of people, when they move to Portugal, they do not initially think about wills or estate planning. So starting with the fundamental question, is it worth making a will in Portugal, and is it mandatory to have a will here?
I will start for the second question. It's not mandatory to have a will in Portugal once you come to Portugal. But it may be if you have a property, a house, an apartment, if you have some significant assets, golden visa funds, some relevant money in the bank, then it will make all the sense to have a Portuguese will. There's something that people have to bear in mind. According to EU regulation laws, which is applicable for all those residing here, the law applicable by default is the law of the country where you have habitual residence by the time of your death. If you reside in Portugal and if you die in Portugal, then there is a tendency and there is a law that will apply by default the Portuguese law. Portugal has forced heirship, meaning normally, typically, people only can dispose of 1/3 of their assets. The rest has to go mandatory on a first instance to their kids, to their children, and their spouse. Many of our clients, for instance, want to give everything to the spouse in a first instance, and then when the spouse deceases, they leave the things to the children, or can want to leave to someone else. If they want freedom in their way to then it would all the sense to have a will, and in this will you can, the first thing is you choose the applicable law, who can prevent a lot of confusion and can safeguard your freedom to dispose your assets as you wish. On top of that, it can make the life of those that remain, of your heirs, much easier, and can avoid a nightmare of bureaucracy, of confusion, which sometimes leads to litigation and conflicts among heirs, frozen assets that you have difficult to take care of and to use. And a process can take years, can be extremely time consuming, and then later can eventually even lead to litigation, which related to inheritance can take decades in Portugal. So for all the reasons, and for clarification reasons and simplification reasons, and to make to safeguard your freedom to dispose and to protect your heirs, for all, I think it makes all the sense that you make a will in Portugal once you have a house or real estate, once you have some significant money or funds, for the golden visa funds deposit in your bank account. Also, if you have children, you can appoint a guardian to your children in your will. Of course, the last decision, it's from a court, but it is your, whatever you say in a will, it's very relevant. And you can also appoint a financial guardian for your child in the will. So this is all, and you can also appoint someone that will help the heirs in the inheritance process. So all these, the more you prepare in an organized way with professionals you trust, the easier the life of those that remain here will be. So it's definitely, I've dealt with many inheritance process with cross-border situations, and the legalization of documents. There are countries where there is no apostille, and understanding what is the final will in a given country, what is the applicable succession law, to make everything to the interpretation of foreign documents in Portugal, everything. It's very important to do a will if you have significant assets in Portugal, if you have children, if you have things that you'd like to clarify.
Mm-hmm. And I think you briefly talked about this, but just a follow-up question. What happens if someone owns assets in Portugal but does not have the will here?
So then by tendency, they will try to apply the Portuguese forced heirship by default, because this is what is written in the EU succession the EU succession law, Brussels 4. It's that by default, the applicable law to someone residing in Portugal will be the residence, the country of habitual residence at the time of your death. So there's a tendency, and there's a law that indicates to the application of the Portuguese law. And if this is not what you want, you should clarify that in a will. On top of this, you may face, if you do not have a nightmare of bureaucracy that can make it will be extremely difficult for your heirs to navigate a foreign system with different regulations, with the necessity to legalize all the documents, and to navigate a country whose bureaucracy is still very unstandardized.
Mm-hmm. And another topic that often surprises people is that inheritance laws can be quite different from country to country.
Yes.
And Dr. Sandra, could you explain, in Portugal, can people freely dispose of their assets, and what are the legal limits if there are?
So typically, in a normal situation, you can only dispose of 1/3. In the majority, there are exceptions. In the majority of situations, the 2/3 have to go to legitimate heirs. At the first instance, the children and the spouse. If you don't have children or spouse, then the parents also enter. So typically, you can dispose of 1/3 of your inheritance. There are exceptions, but this is the general rule. So there is forced heirship, which is not the situation in US or in the UK, and the majority of our clients don't want to be forced to comply with this forced heirship and want to dispose more of 2/3 of their estate.
Mhm. Yes, and now talking about the types of wills in Portugal. The next question for people who are interested becomes, how do they do this? So, could you explain the types of wills that exist
Yes.
in Portugal and the procedure for drawing up a
So
will?
I think you can make wills in three. You can make in a public notary, in a private notary, in a consulate. This is where you can make wills. We have closed will, public wills, and this is the one that we normally advised, that are done by the notary and kept on their books. The notary verifies if the identity of the person, if the person is capable of understanding what he is disposing, if his will is expressed in a totally free way, if he is not being coerced in any way to draft his will, to write his will. And also the notary verifies if the will and what you establish complies with the Portuguese law, and then would not have a problem to be executed. So this is the public will. Then you also may have testamentos raros, closed wills, which can be done privately, but have to be approved by an instrument by the notary to verify its legality, and then they can be kept privately or in the notary safe deposit, or in the notary public records, So, but normally the most common way is the public will done by the notary directly. And this is the most secure, normally the best option.
Okay. And another practical question that many of our clients also ask, can someone create a Portuguese will remotely, or do they need to be physically present in Portugal?
The answer unequivocally is no. There are many documents and juridical documents that can be done remotely. The will was accepted from those contracts and those documents, because it is very important that a notary testifies that the identification of the person is capable of understanding what he's doing, and that nobody is forcing the person to draft that will, to dispose of their estate in a certain way. So it's very important that it is done in person because of these three important aspects.
Mhm. And I can see we're getting questions in the chat, so I will just take some questions. We have a question from William Royce. Can Portugal dictate what happens to a bank account or other assets in a country other than Portugal?
Eventually, yes, but it depends on what is written in your will and what you have especially set. It depends. Eventually, it can. And that's why it's also important to clarify exactly what you want and how you want it what you want to happen.
We also have another question from Rhoda Kirkwood.
Mhm.
What would happen if you have no spouse or offsprings and have property?
Then then the other heirs that the Portuguese law nominates, or the other applicable law will be the heirs. So if you don't have a spouse, it will be your parents. Then if you don't have spouse, children, or parents, it will be your nephews and nieces or your siblings. So there are certain categories of heirs in the Portuguese law and in other laws.
We'll have another question from William Royce. What trustworthy attorneys are available to write a will?
So the attorney can help you, but normally the attorney can help you understand and to help you draft, but then I think it will have to be done or formalized by a notary. So there are attorneys that can help. We can help at our office, but there are other attorneys that can do that, but it has to be formalized in a notary. So it's a very bad idea that someone decides to write in a paper or just to write a simple document with a lawyer, or to write in it to dispose on their estate. It's to be formally accepted as their last will to dispose on their estate. It has a strict formality, so it has to be done by a notary, or at least approved by a notary through a formal instrument. So it's a very bad idea just to ask your lawyer to draft a will, or to write in a paper what you want, how you want your estate to be disposed. This is the kind of stuff that it's complex, especially when you have cross-border issues. It's complex, it's very formal, and if you don't do it the right way, then it can be considered void.
And another question from Kimberly Feng. To clarify, if I have a foreign will or trust, that doesn't always apply for Portugal assets. Is that correct?
It may or not. It depends on what you wrote in that will. But it's also important to know that a foreign will in most countries, then first, to be applicable in Portugal, has a long and complex process. First, there's the grant of probate. In many countries, you have to have sometimes to go to a court to establish that that is a valid will and that is the person's last will. Then it has to be notarized and apostilled. Then it has to be translated. Then it has to be interpreted by the Portuguese authorities, which sometimes are not familiar with foreign documents. Then they will have to determine what is the applicable law in that case, if it is not written black and white in an instrument in Portugal. So I think that it can, and through my experience, this can be a nightmare of bureaucracy, and these can cause the assets to be frozen, and that the heirs cannot dispose them and cannot even protect them and take the necessary measures. If it's a house, it may need some maintenance and some things. So this is a way a foreign will can be valid in Portugal and can be executed in Portugal, but this may be a very complex and can be a nightmare of bureaucracy.
Another question from an anonymous attendee. We are residents and live only in Portugal. We have no children. If my husband dies before me, will our assets be automatically transferred to me with a will or not?
Yes, this will be the normal situation. Yes. But there may be questions in respect to the applicable law, or in terms of bureaucracy. If you have significant assets in Portugal, it may simplify your life a lot to have a will here.
We have a question from Jane Slovan. If you hold assets through an investment organization in the United States, and each IRA or money market specifies the distribution of those assets upon death, would those have to be formalized in a Portuguese will?
I think no, but I think it would be relevant that you say in a Portuguese will that you want American law to be applicable. So there is no doubt that American law would be applicable to that will. And if you, in the meantime, bought a house here, it would make sense that you have a Portuguese will limited to the assets seated in Portugal.
Mhm. And another question from Rhoda Kirkwood, inquiring about the costs involved in this process.
Yes, it depends on our involvement of how many hours and what exactly you want us to do. But if you have a specific request, send us an email and we will answer to your specific, because it's a little bit case by case. It depends on what type of advisory or help or legal assistance you really need.
Mhm. And another question from William Royce. I don't know if this applies, but in the United States, we do not have any separate regimes for joint or separate assets, the way you do in Portugal. How
Mhm.
does one determine the marital regime when coming from the US to Portugal?
So we will have to analyze their concrete situation and understand first what is the applicable law according to international private law rules. First, we will have to understand what is the applicable law to the regime of assets, and then once we clear what is the applicable law, we will see which will be the regime of assets that will be applicable.
Mhm. And another question, is there a problem having two wills, for example, in the UK and in Portugal?
I think in some cases it may be a good solution. You may have a Portuguese will and a UK will, and the Portuguese will, you would, one of the main aspects you will clarify is the applicable law and what assets you want, how you want the assets located in Portugal to be distributed to your heirs. And you can clarify that this will is only applicable to assets seated in Portugal. And
I
you
see.
can also mention that you have a UK will, so there is no confusion in respect to the
Yes.
object of each of the wills.
Mhm. And we have a question from Lascelles and Valerie Brown Beckford.
Yes.
What documents are needed and how long does it take to make a will in Portugal?
So you will need the first hello, Valerie Lascelles. Hope you are doing well. You have been good attendees of our webinars. So typically you will need your identification documents. We will need the identification of your heirs. We will need ideally the identification of your assets located in Portugal. These would be the main documents. We in Portugal is always important to present witnesses that also you will attest your identity and that you are in full possession of your capacities when doing the will.
And they've also asked another question. Can we have two wills, one just for the local assets in Portugal and one for our home country?
Yes, of course. Then this is normally the solution. I think it makes more sense.
Okay. I will take some of the other questions later on and I will continue. So, to talk about Portuguese wills in relation to foreign wills, if
Yes.
someone already has a will that includes their Portuguese assets, do they really need a Portuguese will? I know you've talked about this, but if you
Yes, but
can
I think
tell us.
it might, if you have significant assets here, I would say so. So if you have significant amounts in your bank account, if you have golden visa funds, if you have a home in Portugal or property in Portugal, I would say yes. Because if you have a foreign will, many times the first thing you need to do is a grant of probate. So you need to prove in Portugal that this will is valid and this is your last will. Then, in many countries, you have to legalize and apostille these wills. Then, you have to officially translate them to Portuguese. Then, there is the risk of the Portuguese authorities not to interpret them the right way. And then there is also the risk of the Portuguese authorities thinking that according to Brussels 4, the EU regulation for succession, which is applicable for those residing here, that the Portuguese law should be applicable. And so you are limited in your ability to dispose your estate. That being said, I think it can simplify and can avoid a nightmare of bureaucracy if you don't have a Portuguese will. That being said, if you don't have children, if you don't have assets in Portugal, if you is not nothing relevant you want to care about and you have a foreign will, and in this foreign will is very clear which law should be applicable, then eventually you might not need a will. Not all the situations, but if you have children, if you have golden visa funds, if you bought a house, if you want to establish something, I think in that situation it will make all the sense to have a will.
Mhm. And when people do choose to have two wills, one in their home country and one in Portugal, should the foreign will mention the Portuguese assets or should it exclude
I think
them?
it's a good thing that you are saying both in both wills that this will be applicable to Portuguese assets and to clarifying the other that this will be applicable to other assets, because then there is no confusion in terms, and it's clear that the last will didn't revoke the previous one, which can be a question.
Mhm. And another topic that comes up frequently is taxation.
Mhm.
Dr. Sandra, could you clarify if there is inheritance tax in Portugal or not?
In Portugal, for children and spouses, there is no inheritance tax. For other heirs, you may pay 10% of stamp duty. In comparison to
Mhm.
other countries, then, for instance, France, this is huge. This is a
Okay.
huge benefit.
Mhm. And another question, if both parents pass away, what would the children, especially if they live abroad, what would they need to do in order to claim Portuguese assets?
So, if you have a Portuguese will, their situation is much simpler.
Mhm.
Then if they do not,
Okay.
if there is not a Portuguese will, first you must make sure that there is a death certificate of your parents. Then you have to find out if there's a will in Portugal, so you go to Conservatório de Registros Centrais. Then you have to establish what is the applicable law. Then you have to go to the tax authority to declare the death and to what are the list of assets. Then you can pay the taxes. Then you should get NIFs. Then
Mhm.
you should do something that is the deed of heirs to establish who the heirs are, and then you should do a deed of the division of assets, and then later to register everything. If you do not have a will, if you do not have a trusted person in Portugal that can help your children doing this, it can be a nightmare. It can take years. The assets may be frozen for a long time. They cannot access your accounts and your properties. And sometimes these complications lead to litigation and conflicts that can take decades. So I think on the one hand, there's the problem of the applicable law. So you may not dispose of your assets with total freedom if you don't have a will or other instrument establishing what is the applicable law, and you can have a nightmare of bureaucracy also.
Mhm. And another related question to this, how can someone find out whether a deceased person has a will in Portugal? What is
As I
the
said
process?
previously, all the wills, there should be this information in the Conservatório de Registro Central. So once you prove your legitimacy as an heir, then you can ask if there's a will. So all the
Okay.
wills should be registered. They
In
should
them.
know all the existing wills. Another thing, if you want to know if your parent had a bank account in Portugal, once you prove your legitimacy as an heir, you can go to the Bank of Portugal to know if there's a Portuguese, if your parent had a Portuguese bank account.
And another question, do you also help with the inheritance process and what are the main legal steps that
Yes, we do. I already mentioned that, but I would say let me do. It's a complex process, so there are many intricacies and details. The first would be there has to be a death certificate. Then you have to verify whether there's a will or not. Then you have to verify what is the applicable law. Then you have to declare before the tax authority. Then you have to pay taxes. Your order may not be exactly this. Then you need to do a certificate deed of heirs. Then you have to agree with the other heirs to divide the assets. And or if there's a will, it's needed that you follow whatever it's written and established in the will. Then you have to register everything. In the mean of the process, typically all heirs and their spouses need to have NIFs in Portugal. It seems simple, but it may be complicated, especially if things are not pre-prepared in a black and white way. And if you do not have a trusted professional assisting you that was already preparing all this to simplify any types of problems.
and coming to some more specific questions that many international families ask, what is a vital testament and how does it work in Portugal?
So a vital testament, it's completely different from a will. It has to do in your last disposition in terms of medical things or even in respect to your organ. So if you may establish in a vital will someone to take these health decisions on your behalf if you are not longer conscious, you can also establish if you wanted them to switch or not the machine in certain limit situations. You can establish if you want your organs to be donated or not. All these things have to be done in a vital will, and you have to do a vital will in Portugal for it to have efficacy here, to be applicable here, and has to be registered here before the competent authorities.
And many of our clients also have cross-border families and assets. So
Yes.
few practical scenarios. Is it relevant for inheritance purposes to have your marriage transcribed in Portugal?
In some, not always. It's really mandatory and important if one of the spouses is Portuguese. If one of the spouses is not Portuguese, then it may not be as relevant as if one of the spouses is Portuguese, is mandatory. If not, it depends.
And finally, in relation to the NHR tax period, are there any implications related to inheritance during or after the NHR period, or is this
I
not
think it
related?
has, I think this question came up, but it has nothing to do with one another. So NHR was a tax benefit initially in an initial way for pensioners residing in Portugal. Initially, they were totally exempting from paying taxes in respect of their pension if they resided in Portugal, with some exceptions. Then they had to pay 10%. In the meantime, this old regime was revoked, and now we have NHR 2.0, which is not applicable to pensioners, but for those with high value activities such as scholars, researchers, doctors, and some with innovative projects, and they can benefit from a 20% flat tax rate of their income in Portugal. And especially that is quite important, they may have in Portugal a total exemption or on the majority of their passive income generated abroad.
Okay. And before I move on to some of the general questions, I have been seeing we've been getting a lot of questions in our Q&A. So just to take them, from William Royce, is it possible to leave assets to the spouse first for the use of the spouse until the spouse's death? When will it be dispersed to the children?
I don't know
This.
if
Mhm.
this is totally understandable, but um, in according to Portuguese law, if you have children, you cannot leave everything to your spouse. You are limited. Two-thirds have to go to the spouse and the children. Um, so if you want totally freedom to dispose your assets, you should nominate as applicable law the law of your country of nationality if this law allows you to dispose of everything. But if you in any way are not against mandatory laws that are applicable in that case, it is possible that you grant the right of usage to your wife and then the property itself without the right of usage to your children. But we have to understand which law is applicable in this case and if this disposal doesn't violate any mandatory laws.
Mhm. And another question from Edward Coltman. Would you
Yeah.
explain what determines habitual residency if one resides part-time in several countries?
There is a notion in international private law that normally habitual residency and with conventions is the place where your family is centered, your family life is centered. So where you have an habitual abide, where you are tax resident, where you work. So these typical, and you cannot be tax resident in two countries at the same time. Your family life typically is centered in one country, and typically you are tax resident in one country, and that country that house should be the country that is considered tax resident. This may be confusion, there may be conflicts, but the jurisprudence has had this concept of the country where there is a stronger connection with your generally family life. And typically, I would say the country where you're really tax resident and you really reside.
Mhm. And another question, I don't have children, nor are my parents alive anymore, but I do have a common law spouse. Will common law be recognized? And what if it is a same-sex common law?
Yes, common law can be recognized, but in case of a common law spouse, this is the exact case, and this is one of the type of cases that makes all the sense. If you have a will, you can simplify things enormously. We have had very, very complex cases of people that had de facto union de facto spouses, and it was extremely difficult even for them to get their pensions, to obtain the pensions from their partner, because there was not a will. A will in that situations can simplify things enormously, and also a document certifying and attesting the validity of their union.
Mhm. And another question, can I make a notarized will in Portugal to say that my Canadian will should take precedence?
Yes, I would say yes, but perhaps it may not. I think most important thing would be the applicable law, which law you want to apply here, and also other stuff, but eventually yes.
And a question from Rose Stasis. My husband and I both own a house and financial assets, but only I can travel to Portugal to do a will. How do we do this if my husband cannot go to Portugal personally? Can he get the documents done here and notarized here in the United States?
No, this is one of the few juridical acts that cannot be done remotely, but you can go to a Portuguese consulate and that can be done in a Portuguese consulate, but that cannot be done remotely. So eventually you might go to a Portuguese consulate and do it there.
And a question from Gordon Fanshawe. If you have a house in Portugal, how is it divided among spouse and or children?
It typically, I would assume that your spouse is already the co-owner of 50%, and the other 50% should be divided by the spouse, the spouse and the child. But if you want, I think in those situations again, it would be very important to, if you have a will, then it will be black and white exactly how you wanted to do it, because you might eventually want to prevent your child to sell the house while your wife is alive. So you, as the previous, eventually you may say that you want US law to be applicable, to have totally freedom to dispose of your assets, and you can establish that your wife would have the right of usage, or establish whatever you want with total freedom and clarity. If you have a will, it's important, and it can clarify and bring transparency and to make it simpler to execute whatever you want to do in a process that with a will in Portugal would be for sure much less bureaucratic.
And another question from William Royce. If I die and I have no children, would my spouse have to share the inheritance with my nearest relatives, for example, an uncle and a cousin?
If I don't know which, in your case, which law would be applicable. If it is the Portuguese law applicable now, your spouse, if the Portuguese law is applicable by default, won't have, if you own, won't have to share your assets with your relatives.
And another question from an anonymous attendee. Is there any methods to make an EU-wide will?
Yes, it's possible. Yes.
And a question from Stephen Bellinger. Do bank and investment accounts in Portugal allow the assignment of assets to a person with the intention of bypassing probate as they do in the USA?
I think the easiest way to bypass probate would be not possible, because once you die, your bank account will be frozen in Portugal. So what would be relevant and important and to deal with this would be to have a Portuguese will, and to say that this will is limited its application to your bank accounts here, and then in that case you don't need probate, because there's not necessity for probate for the Portuguese will if you have a Portuguese will already.
And another question from him, are international wills commonly included in will preparation in Portugal?
Yes, there are, but I think to simplify things, sometimes if you don't have a super complex inheritance, it may just be easier to do a Portuguese will for the Portuguese assets here that are located here.
And a message from Lascelles and Valerie Brown Beckford. I may have missed this response, Dr. Sandra, but once the will is made, how is it registered, or where is it registered?
Typically, it's a public will, so it's done in the notary office and it is kept in their official books. And also the notary certifies that the person, its identification, that the person is capable of and in this full possession of its capacities to understand the content of the will. So it's registered in the typically, the most common way to do it is to have it registered in the official book of the notary.
And they've also asked if you could explain a little bit about the living will and what's involved.
So the living will is, as I told, that you have to establish if you are not in possession of your capacities, who would take health decisions on your behalf. Also that if the machine should be switched on or not, if you you want to donate your organs or not, and to have it valid in Portugal, you should do it in Portugal, and it must be registered before the Portuguese authorities, namely the health authorities here. So it can be applicable and valid here, enforceable here.
And a question from Wayne Meliado. If you become a resident of Portugal and have a Portuguese will, can this apply to UK assets so you don't pay inheritance tax on UK assets?
It depends. It depends. To depend on your specific situation. It would have to be, we would have to analyze your decision, your situation in detail to give an specific answer for your case. Eventually, this is something that could be prepared, but we have to analyze your concrete situation and to understand what would be the best solution tailor-made for your case.
Yes, and a similar question we've also gotten from Andrew Hobbs. If you have property assets in the UK, can the Portuguese law be applied to those if specified in a UK will?
I would say yes, but there are other requirements that have to be met, and this is eventually a situation that we could analyze. If you send us an email, we will analyze your specific situation because some requirements, additional requirements, specific have to be met.
And a question from Leslie King. If the bank account is jointly owned by both spouses,
Yes.
does it get frozen if only one spouse dies?
No, eventually the other spouses can, it depends on the types of bank accounts and what they establish in the bank account. Uh, but in some cases that can happen. So it's, I think it's, if you have everything in a will very black and white and you have no difficulties in proving the situation of the inheritance, this can be simplified. Typically, no, but there can be situations where the bank account is frozen.
And a question from Jean-Louis Levine. My Portuguese will only says that the applicable will be my country of origin's will, which is Canada. Is this sufficient or should I have my Portuguese will amended?
So if it's the law, I think one of the important things to be said in a will is to establish the applicable law and to say that the applicable law will not be the Portuguese law, with according to EU regulation, will be the law applicable by default if you reside in Portugal by the time of your death. So I don't know what you wanted to clarify in your will, but so it's a very specific concrete situation, but it made sense. I don't know what you wanted to do in that will.
Mm-hmm. And one of the last questions from Charlie Freitas. I am Portuguese, but my spouse is Canadian, also common law. Do they have to be present when filing the will? I have no document proving it's common law.
No, I think a will, it's a very personal thing. So each person does a will individually, and it's a secret document. So nobody can access to it, not even your spouse. So typically, for your spouse to be present, the notary will ask if this is really what you want. So he doesn't have to be present because it's an individual act, secret act that not even your spouse can access to that.
Yes. And just the last question from Lascelles and Valerie.
Yes.
How can your power of attorney support with the will process?
So if you have a power of attorney to your spouse, you can dispose that your spouse can do a lot of things on your behalf. So that can be also something that helps. Even in the period that if you are ill or something, the spouse can act on your behalf.
And Dr. Sandra, now for some general questions.
Yes.
We talked about the NHR, but could you tell us more about the NHR 2.0 and what are some of the benefits that come with this new regime?
So I think I already told. So the NHR 2.0, it's a completely different regime from the previous NHR. So it's no longer applicable generally to pensionists or retirees. It's only applicable for those with high value activity, value professions, such as scholars, researchers, tech people, and those that have startups with innovative projects that were approved for that effect. And you can benefit for a 20% flat tax rate of income generated in Portugal and a general exemption on your passive income that you have elsewhere. And this can be huge if you have a lot of savings generating income.
And on a more general topic, could you also tell us about what are the most recent changes with the citizenship law in Portugal?
So there are changes in progress that were already approved by the Parliament, but these changes are not yet in force. So if you reside here already for 5 years, you can still, the old law in its general most important terms is totally applicable. So you can, the old law in its most important features is still applicable. The new law was already approved by the Parliament, but is not yet in force.
Mm-hmm. And with some of the changes at the AIMA, what are you seeing on the ground, and have there been any relevant changes with the process?
I think that there have been some changes. Renewal are proceeding still with some backlogs, but in a better way. I'm seeing sometimes even with a huge backlogs, we are getting appointments, which was not the case 1 year ago, but it was extremely difficult to get appointments. I think things are a little bit more clarified in terms of proof of accommodation. So the crazy things that were being asked in summer, such as the citizen card of the landlord, typically are no longer being asked. But still, they are very demanding in having all the originals, all the little details. But we think it's getting the process is a little bit better in general. I think also they clarify that prorogation of residency cards will no longer happen, and also that typically after your residency card expired within a 6 month period, you are still okay in Portugal.
Mhm. And with regards to the most common visa pathways to Portugal, there's been a lot of discussion about the unavailability of visa appointments. And I think this is also important for a lot of our viewers. What are your comments on this, and what is your strategy moving forward?
I think that this is a serious matter. I've been talking a lot of time that the D7 and D8 are some of the the best visa options to have residency in Europe and later to even acquire permanent residency and to have free travel throughout the Schengen space. I believe that this will end or will be more complex and more demanding sooner or later. So I believe that this may be a sign, I don't know for sure, but actually the diplomatic authorities, Portuguese, are not granting available places for the D7 and D8. I believe this might be a sign that there might be additional restrictions and limitations for the D7 and D8. So I think those that really would like to take advantage of these visas, it might be one of the last opportunities to do it because I had some clients asking in Washington in a clear and direct way, and their answer was that the Portuguese authorities were not making slots available for D7 and D8. Some other visas now, student visas and D2 still have slots. So I think this may be a sign that there is a political intention to reduce the possibility to come under D7 or D8. And yes, this might make they may follow a strategy of not having so much retirees in Portugal, but also attracting people that would be NHR 2.0 holders, meaning people that could help to innovate and to develop the country. I don't know, but this is what makes sense according to the what I have been observing throughout the years.
Mhm. And since we're on the topic of visas, could you also talk about briefly about the pain points of the visa process and how do you assist your clients looking for full support with the
So
visa?
we try to be someone supporting and accompanying the clients throughout the whole process. So we don't want anyone to feel uncertain, to feel alone, to feel not supported throughout the process. And so we have also developed, and we every week we try to understand how can we do this better, how can we be of service. And now we are helping not only in the most important points, but we are trying to give an additional help in some less important moments, but still moments of a lot of uncertainty and anxiety while people are waiting for the card or while people are waiting for the visa to be approved. So typically, if you want to start with us today, we will do an agreement. We will do an agreement. I will ask the documents for the power of attorney. We will issue a power of attorney. We will give you the documents for the visa. We will start to get an appointment taking into account whatever you want. This is simplified in a nutshell, in a very simplified way. And I would be having, and me and my team, we would be having meetings with you, explaining each and every item of the process as I am doing now. We would explain in detail everything of the visa process. We will get appointments on your behalf. We will fill in the forms on our behalf. We will try to be very attentive to any variation or oscillation or novelties that are constantly putting in the visa process. And then by the time you have the visa appointment, we would have checked, double checked, triple checked all your documentation, and we will do an additional special meeting to prepare you for the meeting itself. After the meeting in the consulate or VFS, we would verify to see if there's any problem within the process while you're still waiting for the passport to be stamped and approved. And so we are in constant contact with the consulates to know what is going on. And we know that after you go to the appointment and before your passport is stamped can be a moment of a lot of uncertainty, of anxiety. So we try to be in constant contact with the consulate during that time to understand what is going on, because there is a track number, but not always efficient. After when the person receives the passport, we check to see if there's an AIMA appointment, or then if it's not, we get an AIMA appointment for the client to end the process here in Portugal before the immigration authorities, which is the AIMA. Then typically we prepare a file for the AIMA appointment. We fill in the forms for the AIMA appointment. We check and update all the documentation for the AIMA appointment, and typically you have one lawyer from our team that will go in wherever place in the country to assist you to your AIMA appointment, and this typically takes one day. And then after you have the AIMA appointment, we will be monitoring and checking with AIMA to understand what is the status of issuance of your cards, because we understand that this is also a moment of enormous anxiety. And then typically after the AIMA appointment, your residence card is issued and you can be resident in Portugal for 2 years, and then you can renew it for additional 3 years. And after these 5 years, you can apply for permanent residence, which is almost citizenship, because you reduce the mandatory stay times, and you can have and you reduce also your immigration obligations. So and once you are permanent resident here, and even during the time of your visa, that you won't feel in your life, daily life, that in any way your rights or liberties will be limited because you are not a Portuguese citizen.
Mhm. And before we close, I would like to take all of the questions from the chat.
Yes.
From Andrew Hobbs, is a UK power of attorney valid in Portugal, or is a Portuguese power of attorney also required?
I think the UK power of attorney, if he meets certain requirements, can be valid in Portugal, but it has to be typically apostilled and it has to go through a certain process to be apostilled. Yes. It depends on the situation. Sometimes it might make sense to do a Portuguese power of attorney.
Mhm. And from Jean Louis Levine, is it important to specify in the Portuguese will what will happen to the Portuguese assets like the house, bank account, etc., or just saying that the applicable law is my country's law is enough?
It depends on the situations, but normally it's important to establish what you want to happen to your houses and to your assets here. Yes. Because if
And
it's only established applicable law, there could be another instrument that you could do
Mhm.
instead of a will.
And another question from William Royce. We are D7 holders. Does this mean we will not be allowed to renew our residency at the end of our first 2 years?
No, of course not. I think within 2 years, you should be able to renew the D7. Even if they change the regime, we do not expect at all that this will be applicable to those that are already D7 holders.
Mhm. And the last one from Stephen Bellinger.
Yes.
Can or should a will be made in Portugal by a person with assets in Portugal, but who is not a tax resident?
It depends. If the assets are significant, I would say yes, but I would have to analyze the concrete situation of the person. But you don't
Mhm.
have to be tax resident to do a will here.
And just the last one that we got another one. Can you expand can you expand on working and residence balance, please? I'm starting a European company that will require me to be away from Portugal for a considerable time.
But what was the question?
I think he's asking about starting a European company.
And I think it's the
So
question's a little bit vague. I
is
don't
a
understand, but you can send us an email and we'll be happy to help you, to assist you and to clarify whatever you want to know.
yes. And with that, Dr. Sandra, what would be your key advice for international families living in Portugal or planning to move here when it comes to wills and estate planning
I
and
think
with this
that
process?
if you have a house in Portugal or a set in Portugal and considerable some significant amount in a bank account or golden visa funds, it will make all the sense to have a will here. It can simplify a lot by you establishing what law you want to be applicable and how you want your estate to be exactly divided, and that can prevent a nightmare in the bureaucracy and a lot of years of a complex bureaucratic process that can lead to the litigation that can take decades. So if you have significant assets, if you have children here, it will, although the court has the last decision, you can appoint a guardian, you can appoint a financial guardian, and that can be very important. You can establish other things related to the financial aspect of your children. And this preparation of your estate is something very important to protect your wealth. So people are very worried to create a wealth, but then are not that careful in protecting that wealth. And doing a will and other things can be very important to protect that wealth. On top of this, I would say that those that would still want to go for the D7, D8, I really believe this might be one of the last chances to do it. And we'll be, of course, here to help them.
And just a nice comment from one of our clients, William Royce. He says, "Thank you so much, Sandra. You were able to help us so efficiently with our D7 visas, and you definitely have our confidence."
Thank you so much. She's very kind of William to make such a comment.
Yes. And with that, Dr. Sandra, I would also like to thank you for sharing your expertise with us today. And of course, these are incredibly important topics, and I'm sure this information will help many families plan more confidently for the future. And to everyone who has also joined us today, thank you so much for your time. And we appreciate all the questions and the feedback we get. And if we have not answered all of your questions, and if there's still something more you would like to ask us, I will leave our contact details in the chat, and please feel free to reach out to us. And just a reminder, the first 30 people who contact us using the code SGP, your partner to moving to Portugal, will also receive a free initial consultation with our team. And thank you. We look forward to speaking with you very
Thank
soon
you.
again.
Just can you put our YouTube channel
Yes,
also in the chat?
I
And
will.
if you have ideas for future videos or something that you would like to be covered, we will, of course, be creating content that makes sense for you. Thank you so much all
Yes,
also for
thank
attending
you.
today. Thank you, Marisa, for being part of this, doing this so generously.